All right, everyone, please be seated. So that the record can be clear, the last exhibit offered by the states were states exhibits 106 through 110. Is that correct?
Judge, I believe it was also states 111. It was a disc with photos.
And also states exhibit number 111. Is that correct?
Yes, ma'am.
All right. And defense, I believe you had no objections to those exhibits. Is that correct? All right. So just so the record is clear, states exhibits 106 through 110 are admitted. And states exhibit number 111 is admitted as well. And with that state, do you rest?
Yes, ma'am. We rest.
All right. Defense.
Yes, ma'am.
State, do you close?
Yes, ma'am. We close.
Defense?
Yes, ma'am.
Okay. All right. Ladies and gentlemen, what's going to happen now? Both sides have rested and closed. I'm going to read to you the jury charge, or what's called the charge of the court. You do not have to memorize that. You will be given my copy to take back with you to the jury room. Charge of the court. Members of the jury, the defendant, Jose Lozano, stands charged by indictment with the offense of theft, $300,000 or more, alleged to have been committed on or about the 4th day of December 2020 in Bexar County, Texas. The defendant has pleaded not guilty. 1, our law provides that a person commits the offense of theft if he unlawfully appropriates property with intent to deprive the owner of property. Appropriation of property is unlawful if it is without the owner's effective consent. 2, appropriation and appropriate mean to acquire or otherwise exercise control over property other than real property. Property means tangible or intangible personal property or documents, including money that represents or embodies anything of value. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by deception or coercion. Owner means a person who has title to the property, possession of the property, or a greater right to possession of the property than the person charged. Value is 1, the fair market value of the property at the time and place of the offense, or 2, if the fair market value of the property can not be ascertained, the cost of replacing the property within a reasonable time after the theft. 3, a person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. 4, now if you find from the evidence beyond a reasonable doubt that on or about the 4th day of December 2020 in Bexar County, Texas, the defendant, Jose Lozano, with intent to deprive the owner, Terry Kirkbride, of property, namely clothing, electronic items, household items, tools, toys, sporting goods, weapons, fashion accessories, jewelry, magazines, books, paintings, artwork, collectibles, vintage movie items, antiques, motor vehicle parts, military collectibles, United States currency, and or food items did then and there unlawfully without the effective consent of the owner, Terry Kirkbride, appropriate said property by acquiring or otherwise exercising control over said property being other than real property, which had a value of $300,000 or more, then you will find the defendant guilty of the offense of theft, $300,000 or more, as charged in the indictment, and do not consider any lesser included offenses of theft as instructed in paragraphs 5 through 7, but instead proceed to paragraph 8. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of the offense of theft $300,000 or more as charged in the indictment, say by your verdict not guilty of the charged offense of theft $300,000 or more, and proceed to paragraph 5 to consider whether the defendant is guilty of the lesser included offense of theft $150,000 or more, but less than $300,000. 5. Now, if you find from the evidence beyond a reasonable doubt that on or about the 4th day of December 2020 in Bexar County, Texas, the defendant, Jose Lozano, with intent to deprive the owner, Terry Kirkbride, of property, namely clothing, electronic items, household items, tools, toys, sporting goods, weapons, fashion accessories, jewelry, magazines, books, paintings, artwork, collectibles, vintage movie items, antiques, motor vehicle parts, military collectibles, United States currency, and or food items did then and there unlawfully without the effective consent of the owner, Terry Kirkbride, appropriate said property by acquiring or otherwise exercising control over said property being other than real property which had a value of $150,000 or more, but less than $300,000, then you will find the defendant guilty of the lesser included offense of theft, $150,000 or more, but less than $300,000, and do not consider any lesser included offenses of theft as instructed in paragraph 6 and 7, but instead proceed to paragraph 8. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of the lesser included offense of theft, $150,000 or more, but less than $300,000, say by your verdict not guilty of the lesser included offense of theft, $150,000 or more, but less than $300,000, and proceed to paragraph 6 to consider whether the defendant is guilty of the lesser included offense of theft, $30,000 or more, but less than $150,000. 6. Now, if you find from the evidence beyond a reasonable doubt that on or about the 4th day of December 2020 in Bexar County, Texas, the defendant, Jose Lozano, with intent to deprive the owner, Terry Kirkbride, of property, namely clothing, electronic items, household items, tools, toys, sporting goods, weapons, fashion accessories, jewelry, magazines, books, paintings, artwork, collectibles, vintage movie items, antiques, motor vehicle parts, military collectibles, United States currency, and or food items did then and there unlawfully without the effective consent of the owner, Terry Kirkbride, appropriate said property by acquiring or otherwise exercising control over said property being other than real property which had a value of $30,000 or more, but less than $150,000, then you will find the defendant guilty of the lesser included offense of theft, $30,000 or more, but less than $150,000, and do not consider the lesser included offense of theft as instructed in paragraph 7, but instead proceed to paragraph 8. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of the lesser included offense of $30,000 or more, but less than $150,000, say by your verdict not guilty of the lesser included offense of theft, $30,000 or more, but less than $150,000, and proceed to paragraph 7 to consider whether the defendant is guilty of the lesser included offense of theft, $2,500 or more, but less than $30,000. 7. Now, if you find from the evidence beyond a reasonable doubt that on or about the 4th day of December 2020 in Bexar County, Texas, the defendant, Jose Lozano, with the intent to deprive the owner, Terry Kirkbride, of property, namely clothing, electronic items, household items, tools, toys, sporting goods, weapons, fashion accessories, jewelry, magazines, books, paintings, artwork, collectibles, vintage movie items, antiques, motor vehicle parts, military collectibles, United States currency, and or food items did then and there unlawfully without the effective consent of the owner, Terry Kirkbride appropriate said property by acquiring or otherwise exercising control over said property said property being other than real property, which had a value of $2,500 or more, but less than $30,000, then you will find the defendant guilty of the lesser included offense of theft, $2,500 or more, but less than $30,000. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of the lesser included offense of theft, $2,500 or more, but less than $30,000, and say by your verdict not guilty of the lesser included offense of theft, $2,500 or more, but less than $30,000. 8, you are instructed that under our law, no evidence obtained by an officer or other person in violation of any provisions of the Constitution or laws of the state of Texas or the Constitution or laws of the United States of America shall be admitted in evidence against the accused on the trial of any criminal case. An officer's observation of an item in plain view is not an invasion of a person's right of privacy if the officer observing the item is properly in a position from which he can view the property. Also, it must be immediately apparent to the officer viewing property in plain view that the items observed in plain view might be contraband or evidence of a crime. That is, there must be probable cause to associate the item or items in plain view with criminal activity. Probable cause exists where the facts and circumstances within the officer's knowledge and of which he has reasonably trustworthy information are sufficient unto themselves to warrant a man of reasonable caution to believe that an offense has been or is being committed. If you believe or have a reasonable doubt that evidence was obtained in violation of any provisions of the Constitution or the laws of the state of Texas or the Constitution or laws of the United States of America in such event, the jury shall disregard any such evidence so obtained. 9, our law provides the defendant may testify in his own behalf if he elects to do so. This, however, is a right accorded to the defendant, and in the event he elects not to testify, that fact cannot be taken as a circumstance against him. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it in consideration for any purpose whatsoever as a circumstance against him. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by a witness to investigators or officers or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements or reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law as stated to you by the court, and these instructions are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions, which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony, but you are bound to receive the law from the court, which is herein given to you, and be governed by that law. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement, if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine his own views and change his opinion if convinced it is erroneous. However, no juror should surrender his honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you in these instructions, you will acquit him and say by your verdict, not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is guilty or not guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the officer who has you in charge. Do not attempt to talk to the officer or anyone else concerning any question you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the bailiff. Any and all communication relative to the case must be written, prepared by your presiding juror, and submitted to the court through the bailiff. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas, and suitable forms are attached. Are parties ready to proceed with closing arguments?
Yes, Your Honor.
All right, State, you may begin.
Now, the first thing I want to mention is that, don't worry, you didn't have to memorize all that the judge just said. You're going to have the jury charge back there with you. And now, part of it is that there are multiple Well, let me just tell you the elements. In Bear County, Texas. So again, we've proven that this all occurred in Bear County. On or about December 4th, 2020. Again, multiple people testified that that's when the property was stolen and when the trailer was found. Jose Lozano. Again, Edith came in and identified Jose. He was also identified by the fingerprints found on that trailer by the fingerprint analyst who came in and testified. With intent to deprive Terry Kirkbride, the owner of property, unlawfully, without effective consent, appropriated property. Then it lists the different categories of property that were appropriated. And again, those 3 points I just mentioned, that's the crux of this case. Now, one thing that you should have noticed during the reading of the jury charge is valued at $300,000 or more. So there are multiple different parts to theft that you have to decide. So the first thing that you can decide is if we've met our burden of above $300,000 or more. Well, then it stops there. That would be what he's guilty of. If you don't find it above 300,000, then you would go 150,000 or more, but less than 300,000. The further step is, again, valued at 30,000, but less than 150,000. And finally, valued at 2,500 or more, but less than 30,000. So again, you only go to the next step. You only go to the next value amount if you find that the first value amount is not true. Then you go to the next one. If that's not true, you go to the next one until you make a decision. Now, you heard plenty of testimony in this case from officers who were investigating what happened. You heard from Terry, who I know it took a while to go through those photos, but he detailed exactly what property was found at Jose's home and what he was able to identify. Again, that's not all the property that Terry had. It's just what they took photos of. You also heard from Edith, that's the mother of Jose's children, who did state that he lived at that address, that he had brought this property to that home, and that he didn't say where he got it from, who he got it from, when he got it, only that she remembers it was not that long before the police arrived. So again, you've heard plenty of testimony as to the circumstances around what happened to Terry Kirkbride's property. What I want to mention is that there have been plenty of police reports that have been mentioned during the course of this trial. Several times officers, because this happened 4 years ago, they didn't have a great memory of exactly what happened, but that's why they write police reports. But unfortunately, as it says in the jury charge, you're not going to get any of those. It's again, for purposes of refreshing their memory. What I want to say also is that you cannot let bias or sympathy play a role in your decision. You have to look at the evidence that's presented. Now, again, in each of these different lists of the elements, all the elements are the same except for the value amount. That's really where that decision has to come in. And it's whether or not the state, beyond a reasonable doubt, with all the evidence that was brought in, with the testimony that you heard, did we prove each and every one of those elements? I would argue that we did. And I would ask that you find the defendant guilty of theft $300,000 or more. And I'll reserve all remaining time for final closing.
All right. Defense, are you ready to proceed?
Yes, sir. Please, court, counsel. Good afternoon again, everybody. So I want to start off with a couple of housekeeping things. First of all, if you have a dispute about what some of the testimony might have been, do not send a note to the judge asking, can you read us back the testimony of Officer Melanie? Because you're not going to get it, right? The law says you can get information like that, but it has to happen this way. Y'all are deliberating, you get to a specific point that you're conversing about, and juror number 1 says, that officer said this. Juror number 3 says, no, they said this, in response to a specific issue or question. And even a third juror says, no, I think they said that. If you give a judge a very specific question about what you're disputing, then you'll get an answer, probably. But if you say, we want to hear all the testimony of Officer Knocker, that's not going to happen. So don't ask for that. I want to talk a little bit about unanimous verdicts. What seems like a relatively simple case has raised a lot of interesting questions. And you may not agree on all of them. You may not agree on any of them. My request to you is to live up to your oath and decide the case as you see it. And if you get to the point where your decision is at odds with others and you don't come to a unanimous verdict, whether it's 11-1 or 6-6 or 8-4, it doesn't matter. At some point, you are allowed to notify the court and say, Judge, we're deadlocked. And then the judge will give you further instructions. But don't sit back there just like, well, what do we do? Deliberate, try to come to a conclusion. If you cannot, you cannot. First thing I want to talk about is, this is why jury duty is very, very difficult and sometimes. Yes, it's true. All we have is a property case here. Nobody got hurt, thank God. It's not a violent offense. But it was heartbreaking to hear Mr. Kirkbride talk about the things that he'd accumulated over his lengthy career, a very honorable career that he had, and lose them when him and his wife were so looking forward to moving to California to be near their kids. They pared all their things down to just what they needed to take, and then this happens. I'm sure everybody here was heartbroken to hear that story. It was hard to hear him testify about that. I felt the same way. But that's not what you're here to talk about, and that's what you're not going to deliberate about. What you're going to deliberate about is the legal questions that are presented to you. That's whether or not this particular crime was committed. And the first thing that is difficult to talk about is this may have all been done illegally. There's a provision in the law that says basically, if the police officers violate Fourth Amendment, unlawful searches and seizures, the jury disregards the evidence. And the case basically goes away. In other words, what was confiscated in that yard that day, if it was confiscated illegally, the jury is not allowed to consider that evidence. Without those items in the yard, there is no case, right? We know that, right? So how did they violate the law? Officer Knocker told you very clearly, very plainly, that you can't just go to somebody's house and go in their backyard. I guarantee you, every single one of you would take offense to a police officer deciding, I'm going to wander into your backyard, I'm going to look into your cars, I'm going to look through the windows, and I'm going to see what I'm going to see, and maybe I'm going to come back with a warrant and search. And it's absolutely, clearly, undeniably against the law. That's exactly what they did in this case. Not because I say that, not because my witnesses say that. Officer Knocker told you that, right? You don't have to have a fence for it to be your backyard, right? The fact that you live on property that a fence has fallen down or you can see around it, that doesn't mean you just can mosey on back there. Officer Knocker told you, yeah, I send the guys back there just on the safe side. But there was nothing happening that required that to take place. They weren't searching for somebody with a warrant. There was no crime being committed. They just did it. And then he tells you the plain view that's listed in the affidavit for the search warrant is because those officers were back there looking around. Your deliberations, if you were to follow the law and be true to the oath that you took when you started this case, would be, that's the end of our conversation. That testimony is absolutely 100% undisputed. Nobody challenged that. Everyone has a right for their backyard, their property, to be free from unreasonable searches and seizures. It's part of the law. It's part of the Constitution. And the consequence for violating that is anything illegally obtained is not admissible in court. I know that leaves a distaste in everybody's mouth if that's the conclusion you should come to, because you would want the police to do it the right way. You would want them to legally obtain the evidence so that you could do the right thing by Mr. Kirkbride. I get all that. Difficulty of jury service is you have to follow the law because you swore to this, what you're going to do. So I'd ask you to delve very deeply into that question and come to the conclusion that this was illegally obtained evidence. Paragraph 8 tells you very clearly, it's page 8, paragraph 2. Plain view is not an invasion of a person's right to privacy if the officer observing the item is properly in the position where he can view the property. Meaning, if he's legally there, whatever he sees is admissible. We know the answer to that question. That's undisputed. If you feel you have to go beyond that point, I understand. Let's talk about it. Why do we have all these different ranges of values when the indictment very clearly states, and it was read and Mr. Lozano pled not guilty to, over 300,000. It doesn't give you 150 to 300. It doesn't give you 30 to 150 or 2,500 to 30,000. Why do we now have those options when he was never charged with that? Because they didn't prove their case. It's a concession. It's a concession on the state's part that we didn't really get there. Let's give him some other options. That is so unfair. It's beyond description, because he's come here and he's been under indictment for a case over 300,000 that never should have been filed in the first place. And these different options they're giving you clearly indicates that that's the case, right? And how do we know that? Or how did we get there? Officer Knocker told you very clearly, when you go in and seize property, you'd have to do an inventory. All they had to do was give us an inventory of everything they found on the property. And I guarantee Mr. Kirkbride would have put a price on it because he knows his stuff. He knows what it is. He knows what it's worth. And the magistrate by law requires officers, when they execute search warrants, bring us that inventory and file it with the court. Didn't do that either. Officer Knocker said, I wouldn't have done it that way. I mean, I've done these before. This is how you do it, right? And guess what? It's one of the reasons is so they don't take property that doesn't belong, that maybe belongs to the homeowner, and it wasn't even stolen. That's exactly what happened here. Mr. Kirkbride told you, I found this winch thing that didn't belong to me in the property. So we don't know the value, and it's because the officers didn't do the inventory. And I think I know why, and I think you know why. There's a lot of stuff. Although it's mostly, as Mr. Kirkbride said, junk and trash, empty boxes and stuff. They weren't going to go through it all. So what did they do? They took 84 pictures or however many it was. That's not how you do it. Because then now they're leaving it up to you. Okay, here's all the pictures. Here's all these numbers. Figure it out. That's not fair. Do it the right way. Do what the law requires. Leave the inventory and file it with the magistrate the way you're required to do. Now, this case started off with the stealing of the truck and the trailer. What does this indictment say? And Mr. Kirkbride and I talked about that. They never accused him of stealing the truck. It's not in the indictment. They never accused him of being in possession or stealing the trailer. It's not in the indictment. And we know that it takes much less evidence to get an indictment than it does to get a conviction. There just has to be some evidence. They knew they had none, right? And you know they had none. Nobody sees him at the scene. Nobody sees him in the truck. The truck and the trailer are never on his property. There's no evidence of it. Yes, could you assume and speculate that somehow he was involved? Of course you can. But how does that get you beyond a reasonable doubt? It doesn't get you there. It's not any evidence. It's no evidence whatsoever. So the over 300,000 gets much harder to get to when the truck and the trailer are not even involved. This is about personal property that's on Mr. Lozama's property that is a small piece of a much bigger theft. How do they get beyond a reasonable doubt? They can't. There's no evidence whatsoever. None whatsoever how that property got there. There's no evidence of what all is included in that property, and there's no evidence of the value of it, right? That's how we get all the way down to $2,500, up to 30,000. And the last one they didn't tell you, if it's under 2,500, it's not guilty, because that you don't get 0 to 2,500. Why? That's not one of the options. But the reason I think you have to consider that is Mr. Kirkbride said more than once, they left nothing but trash. There was nothing of value, right? There was nothing of value. His words, his stuff, he knows. Don't believe us, believe the state's witness. The big concern is that a jury in this situation starts seeing things or putting pieces together that are not there, right? Well, maybe he did this. Well, maybe he did that. Let's talk about some of the maybes. What do thieves do when they steal stuff? What do they want it for? Oftentimes, many times, is to convert it to cash, right? Because the things that they stolen, they don't necessarily have a use for it. Yeah, sometimes they'll steal a car, but even then, they'll want to get rid of it because they don't want to get caught with it. So where does the stolen property end up? All over the place, right? All over the place. Some was left in the trailer. Some got to be, clearly it got picked through. We know that. Because what did Mr. Kirkbride say? Nothing of value was left. All the big items with the high value, the item that he said was worth $30,000 to $50,000 doesn't appear anywhere. You never see it. He never recovered it, right? And how do we know for sure all that's the case? Defendant's exhibit number 2 on page 6, and for several pages there following, he makes an exhaustive list, 300 line items of things that he made a claim to his insurance company, right? Telling them, I had these things, I don't have them anymore. I'm making a claim on my policy. The vast majority of what was in that trailer is in that list. And what does he tell you? Of those 306 line items, some of those have 10 and 15 items in one line. So it's a massive amount of property, right? And what's also important to get from this list, at the end of the day, and I know Mr. Kirkbride, I'm sure the state will take the same position, you know, insurance companies are not nice people. They're not nice to deal with. They're not fair with you, right? But they paid him $214,000, right? And I'm not sure that includes the truck or not, but let's just assume it didn't. We all know 214 is less than 300. They were never going to be able to prove their case from day one. That's why they're trying to inch it down and let you prove it. But let's talk a little bit about the 214. Common sense suggests when you're having a negotiation and trying to settle your case with the insurance company, either you agree to the amount or you don't get your check. Right? Either you agree or you don't agree. He had a right to continue to pursue it. He could have sued him. He said, no, I'm done. I'm going to take that number. He agreed to it grudgingly. He didn't like it. He didn't want to do it. But you all know common sense tells you when you sign a release, you're telling them, I'm Mr. Insurance Company, I'm releasing my claim against you in exchange for the value that we've agreed my stuff was worth, right? And everything on this list that accounts up to $214,000 was not in my client's yard. These are all the things that were not found, right? Nothing that's on this list was in his possession. And this is the vast majority. I asked him that question, right? How much was left behind in comparison to what you made in your claim? Well, this is most of it, right? He made the bad decision. He made the dumb decision to allow somebody to pawn some stuff off on him. Maybe he paid something for some of the boxes. Who knows? You don't know. I don't know. You're never going to know. All you do know is that a small percentage of this massive amount of property was on his property, and he shouldn't have had it. Yes, that deprived Mr. Kirkbride of possession of it. Granted, that's a given. And I think you can realistically go back there and say, we don't even think it's $2,500, and therefore you get to not guilty. But if you think it's more than 2,500, what is the next level up? Over 30,000. Folks, you can't get past $30,000, right? Why was all that stuff in the yard? There was nothing of value there. It was papers. There was mementos that were very valuable to him sentimentally, but of actual value. And the jury charge describes for you, well, how is that figured out? How do you figure out what value is? It gives you the definition. The thing that I think is most important to look at is when you go back there and you're looking at the different categories and you're looking at the evidence, how do we find beyond a reasonable doubt that the state has proven all of these things? You're going to go in circles because you're not going to find it. There's no eyewitnesses. There's no confessions. There's no admissions. The truck's not there, the trailer's not there, and the vast majority of items that you see in the insurance list is not there. There's a handful of things. And he's taking the blame for whoever was involved in this case. And that's fine. How did this case become such a big deal besides the sad story that's behind it? Mr. Kirkbride wasn't gonna let it go. He's calling the police. He talked to the chief of police. He talked to the mayor. And all of a sudden, everybody's scrambling. Let's get on the ball. It came out in the news. He even said it. After this is over, you could probably go still find it on ksat.com or all these other places. He made people move because they weren't doing right by him. Understandable. He lost a lifetime's worth of things. I get all of that. But you don't just patch together a case and throw the patsy and say, okay, Mr. Kirkbride, we took care of it. We arrested Mr. Rosano. But even Mr. Kirkbride would tell you, yeah, but where's all this stuff? He doesn't have all my stuff. You don't even have any proof that he ever did. It's a sad situation. But if you're true to your oath and you look at the case based on what was presented to you, look at the documents, look at the insurance claim, look at the pictures of a bunch of empty boxes and ruffled things and mementos, not of value, you can never get past $30,000, folks. You just can't. So if you feel that you have to make a finding of guilt, that's the only category that makes any sense. But I would still ask you to look at, is this search legit? Under these circumstances, the way the law is written, as described to you in the charge. And if you're honest, you're going to say, no, that doesn't fly either. And you're going to have to make a finding of not guilty because the evidence was illegally obtained. So please consider all of those things and please honor your oath. And don't feel like by not giving the state the verdict that somehow you're disrespecting or minimizing Mr. Kirkbride's loss, because nobody's doing that. We're just asking you to do what you promised you would do when you took your oath. Thank you.
All right, state.
Thank you, Your Honor.
I just want to talk to you, remind you of a few things Daniel and I have been talking to you about since jury selection. So our burden in this case is beyond a reasonable doubt. So I'm asking you to not leave your common sense on the courthouse steps. Okay, so there's some things that Mr. Martinez talked about that may be possible, right? But I want you to remember the photo of the dog in the kitchen. And remember that just because something's possible does not make it reasonable. Okay, so it's possible a tornado picked up all this stuff and dropped it in Mr. Lozano's backyard, right? That's a possibility, right? But that's not a reasonable possibility. The first three items I don't think we're in dispute here. This happened in Bexar County. The date's not in dispute. Jose Lozano, the defendant, that's not in dispute. With intent to bribe Terry Kirkbride, the owner of the property, we heard from Mr. Kirkbride up here on the stand. I don't think that's in dispute. I want to talk to you about the mental state. Intentionally acted with a conscious objective or desire to cause the result. And we talked about this in jury selection, right? That's the legal definition. But all we're talking about is you took something that wasn't yours and you knew you did it. You did it on purpose. How do we prove mental state? Mental states can be inferred from acts, words, and conduct of the accused. And so in this case, we had heard testimony from Edith Serrano, who's the mother of the defendant's children. At the time they lived together. She said Jose told her, Jose brought the stuff to the house. He told me he bought the stuff. The next element we have to meet here is unlawfully, without effective consent, appropriated the property. Okay, so who did we hear from? We heard from CSI Gonzalez. He collected the fingerprints from the trailer. We also heard from the fingerprint examiner, Ms. Serenil, who matched the fingerprints to this defendant, Jose Lozano. And you all heard, she also took his fingerprints earlier in court this week. The fingerprint that was found on the trailer matched this defendant. This is the laundry list that we went through, and I'm sorry that part of this process was we had to go through so many photos, but I wanted you to see the scope of what we're talking about here. We're talking about a lot of stuff. These folks had packed up everything they owned to move cross country, and so that's why we had to go through all those photos. But those are the laundry list of things that we're talking about. And sorry, that's what we're going through. So that's the photos and the list. The list was admitted as State's Exhibit 48, and that'll go back there with you. You'll have the opportunity to look that over. And then the valuation. So there's been some talk about the valuation. There's been testimony from Mr. Kirkbride. You saw that list. You'll see that other list from USAA. And what I want to draw your attention to on Defense Exhibit 2, which is this documentation for USAA, in the first column, USAA calls the recoverable valuation of the property at $450,000, and then they depreciate that amount, and they settled at an amount after you take out depreciation less than $300,000. But if any of y'all have dealt with insurance companies before, you know that if you insure something for $100, it'd be extremely rare to get the $100 back. So they settled with the insurance company. But I believe the testimony supports the contention that this theft was of property worth over $300,000. We talked about this in jury selection. We talked about if there's a theft and you recover some of your property, is there still a theft? And none of y'all had a problem with that, right? I mean, there's this idea that, you know, Daniel gets his bike stolen, but he gets his bike back. That's not a theft, right? No, that's still a theft. There was still a theft, even if you got some of your bike back, right? And why should we care, right? Well, this is your opportunity to tell the community that this type of crime should not be tolerated. Don't make this okay in Bear County. Don't make this okay in San Antonio. This is y'all's community. And this is your opportunity to protect your community. So let's talk about responsibility in this case. Who had responsibility in this case? The defendant, Jose Lozano. His fingerprint was found on the trailer. This property was found in his yard. Property was found in his house. It's Terry's property in Mr. Lozano's yard and in his house. He has responsibility in this case. You are the exclusive judges of the credibility of the witnesses. So you get to decide, is it reasonable, is it credible that Mr. Lozano bought these items? So does it make sense to y'all that he spent money that he worked for on these items and then left them outside for nearly 3 weeks? Some of these items got ruined by the elements. I'm glad it rained last night because maybe that'll aid you guys in your deliberations. If you bought something for money, are you going to leave it outside to be potentially, and in this case, in actuality, to be ruined by the elements, be ruined by rain? These are some of the items that were found outside the house. This is, oh, Daniel, what are you doing? Oh. There's something going on here. Let me see. So we got, this is a picture of the camper shell that Mr. Kirkbride identified from the witness stand. That's his camper shell, which is also in evidence. There you go, thanks. And this is what the police saw from the back of the side of the yard. So there's the front of the house, this is the side of the yard. So the police get back there, they can see all this stuff back there. And they've already, keep in mind, this is after they've already matched up the fingerprint from the trailer. They've identified a suspect. They go outside, they're standing on the side of the house and they say like, that looks like a bunch of stuff that was stolen from some folks that were moving, okay? So at that point, they go and get the warrant. They go and get the warrant from a detached neutral magistrate, and then they search the backyard and they search the house legally. But does it make sense to y'all that Mr. Lozano would have spent money on these items? I mean, this is a lot of stuff here. Does it make sense to y'all that you would spend your own hard-earned money on something and then leave it outside for almost 3 weeks to be ruined by the elements, be ruined by rain? That doesn't make any sense. And then you can see these items. This has got Mr. Kirkbride's last name on his bags here, his military bags here. And so it doesn't make sense to me that someone would go out and buy this stuff, somebody else's name on it, and leave it unpacked in their backyard like that. You see here, this is Mr. Kirkbride's documentation and handbook for his truck that was also stolen. And to me, you could make reasonable assumptions from the evidence. And the reasonable assumption that I'm making from this evidence is that at one point, Mr. Lozano had access to that truck because the book is in his backyard. Here's some more of Mr. Kirkbride's property. You can see his name right there. This is one of the many pictures of Mr. Kirkbride's military, one of his medals. And I put this up there. There's more in evidence and there's more on that CD that we answered. And you'll have the opportunity to look at that when you're back there deliberating. But these are the types of things that were left outside in the elements to be ruined. But does it make sense to y'all that somebody would spend money on this and just leave it in the backyard? This is a box that's got Mr. Kirkbride's name and address on it. That's something that was left in the backyard. And then we've got the property that was inside the house. So we talked about this cat statue. Mr. Kirkbride identified that. These are some pocket knives. Mr. Kirkbride identified that at least one of those is a family heirloom. We've got a vehicle here. This is that statue that Mr. Kirkbride described to us. So I just want y'all to keep in mind the sheer scope of the amount of stuff we're talking about. This is a 24-foot trailer. That the way I was thinking about it is they loaded it like it was a game of Tetris. Okay, every square inch of that thing was stacked loaded, and then it was gone. And so the police get the fingerprint on the trailer. This is the picture of it. And if you look at the screen here, on that diagram in about the middle of it, it says, I don't know if this is going to display it, but it's not going to work on the television screen, but it says front and then an arrow. So where they recovered that fingerprint is where you would unhook the trailer from the back of a truck. And y'all can make reasonable inferences from the evidence. So a reasonable inference from this evidence, this is a photo of the fingerprint card, which will also go back with y'all. You'll have an opportunity to look at that in person if you'd like. But a reasonable inference from this evidence, when you take the book from the F-150, you take all the camper shell that's in the backyard, you take all the items that was emptied out of the trailer. A reasonable inference is Mr. Lozano took that truck, took the trailer to his house, emptied it, took the cover off the camper, left that in the backyard, and then dumped the empty trailer about 20 minutes away from his house. That's a reasonable inference from the evidence that's in front of you. These are the fingerprints that Ms. Sarah Neal took earlier this week of the defendant that matched the fingerprint that was found on the trailer. It's a palm print, because it was a palm print that was found. So this is a photo of Mr. Kirkbride in his trailer. And as you can see, it's empty. By the time this is on the December 5th. So the trailer is taken on the 4th, and it's found less than 24 hours later, empty. It's in this condition. The fingerprint's already on it at that point. But the stuff's gone. Because the stuff is in Mr. Lozano's backyard. Because Mr. Lozano stole it. These are all reasonable inferences that you can make from the evidence. So one thing that Mr. Martinez said that I agree with is that thieves steal things in order to sell them. And so I believe that is part of the reason why there wasn't a lot of valuable items found in Mr. Lozano's backyard. He empties that trailer into the backyard, picks out the stuff that he wants for his house, sells the valuable items, and by the time police got there, what is left is of little monetary value. But if you remember the last question I asked Mr. Kirkbride yesterday, I asked him, what is the worst thing? What is the thing you missed the most that was taken? And he said, it's the things that I can't replace. The photos, the military stuff, the items that he inherited that he hoped to one day pass on to his children and to his grandchildren. And those things are gone. And they were worth nothing in monetary value, nothing to Mr. Lozano. But they were worth a lot to Mr. Kirkbride. They were worth a lot to his family. It would have meant a lot to his children. It would have meant a lot to his grandchildren. So I'd ask you to think about that when you're back there deliberating.
Check your honor, it's arguing to ask the jury to disregard the law, that value is determined based on definitions given, not what the eventual value is. That's not the law.
All right, ladies and gentlemen, the court gives you the law and the law is in the jury charge. Does everyone understand? All right, you may continue.
And I'm asking you to hold the defendant, Mr. Lozano, responsible for his actions and find him guilty of theft over $300,000.
Thank you. All right, ladies and gentlemen, you've heard all the evidence that you're going to hear in this case. Deputy Laura is going to take you back to the jury room, and I'm going to ask